Dennis has been a longtime friend of Bethel College and a longtime employee of Everence, and um, we consider him a friend of Bethel College. So, Dennis, thank you for being here and taking over.
Thank you, George. Pleasure to be with you tonight. I do welcome the opportunity to join you. I'm joining tonight from my home office in Colorado. Let's hope that technology continues to be our friend through the evening here and things work the way they're supposed to. On occasion, there's a little blip now and then, but we'll hope that it works the way we want it to. So our purpose tonight is to cover the basics of estate planning, and to be able to do that well, we'll sort of run through a number of things here that I think will be pretty easy concepts to grasp and to work through. But I would welcome your questions at the end. And thank you for being with us tonight. And thanks to George and Pam for the invitation. So let's get started on the way in which Everence approaches the whole issue of financial management, which includes estate planning. And with apologies, this might be a little small on the screen, depending on how big your screen is, but there are really four quadrants here to what we call the vine. Lower left quadrant, we like to start with discovering and planning for God's purpose in your life. And then we'll move up to the upper left, living responsibly, working on things like wills, powers of attorney, which we will cover tonight. And then also looking at some other financial kinds of things, including insurance products. Upper right quadrant, preparing for the future, thinking about retirement plans and mutual funds and investments. And then bottom right, giving generously, which really puts together all of these things and is your instructions to where does the dollars go when you check out. So we will not cover everything on this vine, but that gives you an idea sort of how we approach holistic planning. And when we think about estate planning, there are within the certified financial planning curriculum, there are 6 different branches of financial planning: cash flow, protection, investment, retirement, tax planning, and estate planning. And you'll notice that we, Everence, add a 7th branch there called charitable planning, because we think that's an important part for most of the constituents that we work with, is what do we do with the stuff we've gathered when we're no longer here, and how to best do that. So we'll spend a good chunk of our time tonight on that part of the process. And let's go to some of the basics behind why we do this and why we think it's important. So if you're like most of us, talking about death is a little uncomfortable. Yet when we're prepared for it, you feel better or more secure, and you're acting on your faith. Plus, it helps your family. They can avoid difficult decisions, conflicts, and complications. And part of our process, or part of our role in the process here, is to give you a better understanding of those end-of-life issues so that you can be better organized for when that time comes. A second reason that we think this is important is making others officially aware of your wishes puts you in control. You get to determine what happens when you are gone or when you're not able to make decisions, instead of someone else making those decisions based off of local laws. And third, preparing with tools like wills and advance directives minimizes legal problems, minimizes family conflicts and confusion, and it helps ensure your assets do go to the kind of charitable places you want them to go. This entire process, by definition, then becomes an act of stewardship. And the key here is that we do need to make it official. So after we've done all of these things and have this final act of stewardship put together, it means we need to reduce that to legal documents so that your wishes are well known and legally correct. And copies of these documents should go to your family, to your attorney, your physicians, your hospital, and maybe you've already taken some of these steps. And if so, it might be a good time to review and see if any changes in your life might have impacted your preparation. Short little story. In the last 2 months, we had an individual who passed away, and his friends came to us thinking that because he was a client of ours, thinking that we might know about his estate plans. And the reality is we didn't know about his estate plans, but we were able to find a business card from his attorney and connected to the attorney, and the attorney had everything in place and everything was good to go. But the person who died, had not told any of his friends about where and who and how all these things come together. So making it official and sharing with your family becomes a big deal. So as we think about the process of estate planning, almost 2/3 of Americans think having a will is important. So 64% of Americans think that it's having a will is very or somewhat important. And that's a figure on par with other years, despite a 6% decline in estate planning this past year. Of those who have said having a will is very important, 1 in 4 still don't have one. So there's still some work to do. And if you look at the graph on the right there, who is it that has a will? Younger ages tend not to have documents in place. Older do have a little more urgency to get that done. And when we ask, why is it that you haven't done it? The common responses include, well, I just haven't gotten around to it. Or they think they don't have a big enough estate to worry about, or they don't want to talk about death. And so if they talk about death, it might actually happen. Well, surprise, it will actually happen unless the rapture happens. So why is it significant? Well, we've already mentioned that by not having an estate plan in place, the state, instead of you, will determine what happens to your assets. But there's more to it than just the legal ramifications. Yes, estate planning includes the documents and instructions needed to handle your affairs upon death, or if you're incapacitated, but it's also a way for you to have control over the direction of your assets, as well as take some heavy burdens off of the shoulders of your loved ones. Another item of great significance when thinking about incomplete or incorrect estate plans is guardianship. So without proper documents in place and with the untimely death of parents, the state or local court decides who becomes the custodial and financial guardian of kids. And this is an area you really want to provide for and have in your estate plan, and not have the state become the default provider, because it likely means the kids are going to be in foster care for a period of time until it all gets sorted out. And you can short circuit all of that with a will that says, here's who we want to be the guardians of our minor children. And so we understand it's a daunting task, and it's hard to know where to start or how to go about developing a plan. But that's why we're talking tonight, and hopefully this will give you some encouragement to move forward with that process. And with topics like this, it's always good to have a little humor. So here's the dose of humor. So you know when your plan is outdated when there's no reference to your kids and you now have 2 teenagers, or your father is named as the guardian for your kids and dad is now living in the retirement community. Or if you can't remember the name of the attorney who drafted your plan, it's probably a good time to think about updating your plan. One of the important things that is happening in a good estate plan is that you are the one making the choice on a number of important questions. So, for example, you get to decide who receives what share of your assets, as well as how and when your beneficiaries will receive their inheritances. You also get to decide who will be responsible to carry out your intentions upon your death, who will execute or carry out or serve as the personal representative or the executor of the will, or serve as a trustee, who will make decisions and care for any minor children should you and your spouse pass away together, who will make medical or financial decisions for you if you become incapacitated, and what organizations, such as your congregation or Bethel College, might you want to support through your planning. And when we think about a good estate plan, it covers these general areas. It ensures that someone you trust will make decisions on your behalf. It allows access to financial health and legal information, and it streamlines the transfer of assets upon death. Furthermore, it preserves assets for chosen beneficiaries, which can include charities. So here are some steps that in that estate planning process that we think are important to pay attention to. And if we think about these sort of one at a time, the first step here would be to meditate, to carefully think about the decisions you should make, including using your trusted friends and legal experts as appropriate. Remember, you should plan in light of your objectives. Second would be to discern what makes the most sense for your situation. Many people find that when they do their discernment well, the actual steps of developing and implementing the plan are relatively straightforward. Finally, it's important to review your plan, and to do that every few years. I like to think about it every 5 years. Pull it out, read through it, make sure it still does what you want it to do. Or if you have a significant life issue that happens, so maybe the death of a child, the death of your spouse, or some other life event that might impact the way your plan was put together, probably a good idea to pull it out and read through it just to make sure it's a good plan and still does what you want it to do. If you happen to be an Everence member, we think this is really important. And so we have a grant that we provide to Everence members to encourage you to put a plan in place or to make updates to that plan. And even though it's only $50, it's still enough of an incentive there to cause you to pull it out, read it, make sure it's still good. And then if you do incur some costs, we'll help cover those for you. So here are some fundamental decisions that we need to talk through and work through. No matter what the tool is, the fundamental decisions include these: where will those assets go, and which assets will go where? When will assets be transferred, and who do you want to be in charge of making that happen? And it can be a little daunting to tackle this all on your own. And so what I like to suggest is that you identify a good team to help with that, because most people don't want to try and develop and implement an estate plan on their own. There are just way too many decisions and complicating factors, such as tax and estate laws. So identify a good team, and that can help move this process forward and become important in the key steps of the discernment process. So first, you should determine who will lead the process. Will that be you? Would it be a trusted advisor? Maybe another family member? Second, you'll want to identify and include key professionals or specialists to make sure all the details are covered to meet your goals. For example, you might want to include an attorney to help you navigate all the legal ramifications of the estate plan. Perhaps a financial professional to help you determine how best to reach your goals while also integrating your faith and values into your plan. Maybe a charitable advisor or a foundation representative, or somebody like George or Pam to help you determine the type of legacy that you want to leave when you die. You may want to include a family member, maybe even your pastor. And once this all gets put in place, bringing your family and your children into the process becomes a matter of choice. Though every situation is different, in general, we recommend including family members early and as often as you are comfortable. You may want to err on the side of over communicating. Good communication can help your family avoid surprises after you're gone. Finally, love everyone, but pick one person to serve in the key roles, followed by successors. Selecting a committee to make choices sometimes leads to a conflict when decisions need to be made in times of high emotion. So to get started in the process, the remainder of our time here together, we're going to talk about these 5 fundamental tools, and these become the building blocks of a good estate plan. Some attorneys even say that these tools are so fundamental that they won't allow a client to create a will without also doing the other documents that are listed here. After looking at all of these tools, we can also identify some other things that can be a part of your estate plan, followed by particular ways that we can include generosity in the estate planning process. So let's dive in. One of the big factors in estate planning becomes how do assets transfer at death. So beneficiary designations are huge. They're a great way in which to move assets to beneficiaries outside of the probate process. And while we're talking about probate, let's put a definition on that. So probate refers to a division of the court system that literally oversees the distribution of assets. So probate in Latin is proving of the will. And so when we can do things to sort of sidestep probate, that can generally be helpful. And so with apologies for the busyness of this slide, let's talk about 3 non-probate options and then 1 probate option. So if we think about ownership, when you have ownership of an asset jointly with rights of survivorship, and one of you passes away, then the survivor automatically steps into 100% ownership. So many times real estate will be husband and wife joint with right of survivorship. So at the first death, there's really no need to do anything because it automatically transfers over. So that's item number 1 there. Beneficiary designation, item number 2, some assets have with them a beneficiary designation. So think about life insurance, IRAs, 401ks, a transfer on death deed, or a payable on death account, all have a beneficiary designation. And when you name someone to step into your shoes after your passing, that happens outside of probate. And the institution, so the bank or the insurance company or the custodian of the IRA, will automatically make that shift or change once they know that the original owner has passed away. So it takes a death certificate to prove that, maybe a form or 2, but it's a fairly simple and easy process to make happen. If you have a revocable living trust, which is another option we'll talk about a bit later, those revocable living trusts do not or are not subject to the probate rules, and so therefore assets can pass by way of the revocable living trust without having to go through the probate process. Number 4, if all you have is a will, there's a high likelihood that that will be subject to probate. Now, some states offer a reduced probate, sort of a threshold, and if it's under a certain dollar amount, then there's not a need to go through probate. But most states with a will, you do have to go through probate. It's not a bad and awful thing, but it just takes time. So it will likely cost a little bit more on settlement because you're going to have some accountant time and some legal time and those sorts of things involved in that process. But the court system, the judge will oversee, will appoint the person you've named as executor, issue what are called letters of testamentary, which then makes it so that your executor or your personal representative can go to the bank, can go to the insurance company and say, hi, I'm here on behalf of my friend who died, and we need to get this done. I really should add a 5th segment here too, that if you do nothing, then the state will decide where your things go. So if you have no will and no revocable living trust in place, it's called dying intestate, then the state has a set of rules already set up for you. And generally what that means is that if you're married, half of your assets would go to your spouse. If you have kids, the other half would go to your kids. If you're not married and if you don't have kids, then your assets would flow through the line of descent. So if your parents are still living, they would get them. If they're not living, then it would be any siblings that you might have would be next in line to receive them. So for most of us, that would be different than what we would prefer or what we would choose. So it is important there to sort of make sure that you pick the ones you want rather than letting the state do that on your behalf. I mentioned earlier the revocable living trust. And so let's just spend a little bit of time on that because it is a valid option that's available. And essentially, the revocable living trust becomes a will substitute. So it takes the place of the will. It will avoid probate. It does provide privacy because when you have a will and when you're in the probate court system, that becomes a public document. So anybody who wants to could go to the probate court, check out your file, see everything that you had in your estate and where it all went. Now that doesn't happen frequently, but for some people, they get a little goosey about that whole privacy thing. So some people will pick a revocable living trust just to make sure there's privacy around that. There are some myths out there that we need to sort of take care of. One is that if you have a revocable living trust, you will avoid estate taxes. That is not true. There also is some language out there that says if you have a revocable living trust, you'll have creditor protection. And another myth about if you have it in a trust, then you avoid Medicaid issues. Those are not correct. So I encourage you to have that conversation with your attorney because there are ways to do those other things, but the trust by itself will not make that happen. A well-designed revocable living trust will still have a will, and that will is called a pour-over will. And think about sort of like a pitcher that pours over. So what the pour-over will is designed to do is it says to the probate court, if I missed retitling an asset that really I wanted to have in my trust, please pour that over into my trust. And so that will catch anything that maybe got missed. And you see there on the screen a bucket, and really, if you think about the revocable living trust as the bucket, and on the outside of the bucket are the instructions that are in the trust. And while you're alive and capable, you're likely the trustee. You are carrying your own bucket with your assets in it. But the trust document will allow for someone who may not, someone who will live longer than you or be available longer than you to step into your role to carry the bucket in the event that you either pass away or that you become incapacitated. So an incapacity would be when you can't think, speak, operate for yourself. So that can be an important part of this estate planning process. And another feature of the revocable living trust is that if you have family members or beneficiaries that you would like to have a benefit from your assets, but they have some issues in their life that make it difficult for them to manage their own money. So think maybe dependencies or addictions or just are not good managing money. The trust can be the tool to make that work after you're gone. So your successor's trustee can then manage and distribute as you have directed in the trust document. And the last item on this slide, the special needs trust can also be helpful. So when you have a family member who is for whatever reason, on public assistance kinds of programs, if they inherit a bunch of money from you, they generally have to go off of those programs and then reapply for those program benefits after they've spent down that money that they got from you. If they receive that money inside of a special needs trust, that trust has language which says this money is not available to pay for the regular costs of life. It's just to pay for things that the programs won't pay for. So that's a really important part of this planning process. Is if you either have relatives who are on those programs or relatives who you think might qualify at some point in time, to have that language inside of that trust to be able to make that so it's not sort of prohibitive to your relatives there. So again, the revocable living trust generally takes the place of the will. It's going to be more expensive to create because you have to contemplate and list out a lot of different things that could possibly happen. So just be aware of that. And in central Kansas, I'm going to guess that a will and all of the associated documents that we're going to finish talking about here will be somewhere around $1,000, maybe 1,500. The revocable living trust is probably going to start at 2,500, maybe as high as $5,000, just because it takes more drafting time, more legal time to be able to do that. So that's a quick tour on those two pieces. I spent a little bit of time already talking about pay on death, and let's expand that a bit here. So these are ways to avoid probate. Payable on death is a feature that you can place on an account generally held at a bank that says that on the event of my death, my passing, I want this person to become the owner on my death. So payable on death to whoever. The middle one there, if you name a beneficiary on your pension plan or your retirement account, that person steps into your shoes for whatever's left of that plan at your death. And then the transfer on death on the right side there is generally used with mutual funds or securities to also move ownership to another person. And all three of these will happen outside of the probate system. So helpful tools to minimize the cost and the hassle around death. Let's talk a little bit about wills because they are really the building block, the primary starting point for most estate plans. And wills provide sensible provisions for your family and your loved ones, and you can use them to express your wishes for burial, to leave instructions of services and memorials. Many congregations encourage you to have a form on file with the church to say, this is what I want to have done at my memorial service. And so that's a big gift to your pastor and to your family. If you've already said, here are the songs I want to have sung, these are the kinds of things I'd like to focus on in my memorial. Wills can also be a good tool to outline specific family bequests as to who gets the china, who gets the tractor, who gets, whatever. You can use the will to identify that. And it's also a wonderful place to reflect your faith values and your priorities in addition to your commitment to your family. So some people will choose to have some language in the will to make a final faith statement that shows their commitment and beliefs to whatever religion they happen to subscribe to. So those are the basic sort of building blocks of the will and how it functions and works. And let's look at some advantages and disadvantages here for how these things can work. So the will, as I've already mentioned, is a little less expensive. It can be easily updated with what's called an amendment or a codicil. The big deal here is that the will is only effective at your death. So, and it's a simple starting point for where and how to transfer assets. The disadvantages of the will is it generally does require probate. There can be some settlement costs in terms of attorney time and accountant time. It does become a public document, and it doesn't allow for uninterrupted continuity. So the key there is that whoever you've named to be your executor is going to have a little bit of a lag in time before they can get control of those assets, because the probate court has to sort of work its time. And so there can be periods where you don't have access to some of those funds and some of those accounts. In terms of who to have serve as the executor or the trustee for either your will or your revocable living trust, you have some options here. So corporate trustee or an individual trustee or executor. So with corporate trustees, generally what we find is that there's greater expertise because they're used to doing these kinds of things. They can be seen as independent. So if there are issues or challenges within the family about these things, the corporate trustee can sort of mediate those things, and it can save the family time. With individual trustees, likely be less costly because they may serve without having any fee or cost. They also probably knew the decedent pretty well, so can pretty easily interpret what they meant with the instructions they left. Might be quicker. As we think about corporate trustees, Everence Trust Company is available to serve in that role. There may be trust departments at your local bank that could also serve in that way. The big key here is for you to be comfortable with your choice and your decision. And what I see frequently, and actually what I encourage, is if you want a family member to serve in that role, do yourself and do them a favor by naming a corporate trustee in the last position. So it could be your son, could be your daughter, could be a corporate trustee in the third position. And that allows your family members, for whatever reason, if their life is complicated or they just don't feel comfortable serving, they can simply resign. And then it falls down to the next person and ultimately would land with the corporate trustee, which would be capable and able to do it. And recently I've had a couple of conversations with clients who've said, well, 10 years ago when we named our kids, that seemed like the right thing to do, but now their lives are busy and they don't really have as much interest. So we're just going to skip over them and go directly to a corporate trustee. So there's lots of different ways to make that work. But just be aware and have a conversation with the person you've named to see if they're willing and interested to serve. Having that be a surprise to them is probably not the best choice. So as we think about where assets can go, let me offer three possibilities. Talked about this already. Family members certainly are one. Another family member that you might not recognize, Uncle Sam, and his state or local municipalities could be another place in the form of taxes. And third, charities. So maybe your local congregation, maybe Bethel College, maybe the American Red Cross. And the advantage here is that if you don't like one of these three, you can cut them out. So if you don't like your family members, charity is always an option. If you don't like taxes, then giving some to charities will help drop the taxable amount of that. And if you want to put it all to family and not have any charity, then it probably means you'll have a little more tax to pay. But you're in control of defining how that works. And while we're at it, let's talk a little bit about taxes. Our experience is that most people like to maximize the amount that goes to family and charity and minimize the amount that goes to taxes. And in reality, very few people typically are required to pay federal estate tax because the Tax Reform and Jobs Act of 2017 largely doubled the amount of money that can be passed on to individuals tax-free. So in 2024, that number now is 13.61 million that can be exempted from federal tax. If you're married, that's 27 million. So for most of us, the federal estate tax is not going to be the issue. State by state, some states do have an estate tax and some don't. So probably the bigger issue, as we'll see a little bit later, is taxes on unearned income like IRAs and 401ks. At Everence, we like to think about estate planning in a little different frame, and we label it as stewardship estate planning. And some important questions that are a part of that stewardship estate planning is how much is enough for our kids? Secondly, when is it too early or too late to leave money to our kids? Um, Third, what's the best way to leave a gift to charity? And then fourth, have I planned for my incapacity or my inability to act on my own? So we'll talk through a couple of these things here. So um, when people are deciding how much to give to charity, there are some options. So it could be a fixed amount to charity. It's important to think carefully about this and review the amount regularly. So a colleague of mine shares a story as she tells or does this seminar about working as a development officer at a nonprofit organization. Full disclosure, it was not Bethel College. So she was quite ecstatic when the organization she worked for received a bequest of $750,000. But her heart sunk when she got a copy of the will and saw that the woman's congregation had only received 25,000 and a relative had received 10,000. And in this case, the will had been written about 25 years earlier and included specific dollar amounts for the church and the relative, with the remainder going to charity. And my colleague couldn't help but wonder if that was how the woman would have wanted the money to be distributed if she knew the current value of her estate. Because of the unknown costs of healthcare and client needs, along with changing markets, it's impossible to know what the right amount might be in the estate. So another option here, and one that we frequently will recommend, is to think about a fixed percentage. So this can change over time. So for example, generally we start by saying that since we've chosen to tithe in some form over our life, we might want to give 10% of our estate to charity as well. And as our kids become more established and as our own needs continue to diminish, we could change that number to be something greater than 10%. Another option that's available here would be adopting charity as a child. So, for example, if you have two children, you might set up your estate so that 1/3 goes to the oldest, 1/3 to the youngest, and 1/3 to your other child named Charity. So that's a possibility that exists. Fourth, a way to define a certain amount that will be given to children and heirs, with everything else then going to charity through a residual bequest. And finally, for people that, oh, sorry, here, my mouse is doing funny things on me. So the residual there would be the final option that could be available. So and it's possible to do a combination of these things too. So you could adopt charity as a child and then put a cap on it. I've seen that done where everybody gets 500,000 and anything above that then would go to charity. So there are ways to sort of mix and match these combinations. So let's look at a real life example here. So this is an estate from the Snyder family of $500,000 in total. So an IRA of 250,000 and bank balances of 250,000. They had one daughter and they wanted to split the estate evenly. So their daughter would get half and charity would get half. And this is how they imagined the flow would be, that the dollars would flow into the estate and then charity would get 250, the daughter would get 250. What they didn't think about was that the IRA balance had never been taxed. And so as the IRA goes into the estate, that's a taxable event. And so they happened to be in the 24% tax bracket, which meant that $60,000 got sort of erased out of the estate. So Charity got 220, their daughter got 220. And if they would have known better, there's a more efficient way to have done this, and that would be to put a beneficiary designation on the IRA that said, at my death, I want the IRA to go to charity, which then would skip the tax completely. And then the 250 bank balances, which have already been taxed, flow through the estate to their daughter. They could have put a payment on death clause on that to go straight to the daughter also, but that would then not allow any dollars for the estate to function. So that's not the best choice either. Let's talk about some of those ancillary documents. So powers of attorney, and we're going to look first at the durable power of attorney. And this is a document that allows someone else to legally make decisions on your behalf while you're living. And this is a safeguard so that if you become mentally or physically incapacitated, someone else could act on your behalf, to make decisions on your behalf. And so here are some of the powers that are available to the power of attorney. They could do bill paying and banking and buy and sell items on your behalf. They cannot execute a will, revoke a will, or execute a living will, which says, here's how I wish to die. Some important considerations here is that the durable power of attorney can be active now when it's signed, or you could put some stipulations there that say, well, if I had a stroke or if I had a heart attack, then I want this person to be able to act. The biggest consideration is that that durable power of attorney ceases to be effective at your death, and therefore then the will or the revocable trust would step in and take over at that point. So that's item 2 of the 4 major items. Item 3 would be a healthcare power of attorney. And similar kind of thing. This is appointing a person to act on your behalf in the event that you're not capable, and around healthcare kinds of decisions. And generally, this will be a family member who will do this. But it wouldn't have to be. It could be somebody else. So again, think incapacitated, not able to think or speak. Having the HIPAA release be a part of that process is important because then they can receive health documents from your physician that could be helpful. The living will is the next item that's available here that is important to have in place. And so the living will outlines your wishes in the event of either a terminal medical condition or a coma or a non-responsive kind of condition. And it's dealing really with end-of-life issues. And typically our doctors end up being the ultimate decision makers, but this is your sort of recommendation to them to say, here's how I would like to be treated. So important to have that in place. Some states have an option called a physician-ordered scope of treatment, or a POST. And this is a document that's similar to the living will, which says, here's how I want to be treated. And these can vary from state to state, but are generally pretty standard in the language that are there. So if you're feeling overwhelmed with all that I just ran through in a pretty hurried fashion, that's a common feeling. I'll just validate that for you. And the question then becomes, where do we start? Where to begin? So first, I suggest that you list out assets that you own, because that's an important thing to have available. And then you need to make some fundamental decisions on where those assets go and what happens to them. Where you want them to go is an important part. So that general asset summary is a big deal to get your hands around and sort of understand. Having information that's a part of your plan that says, here are the beneficiaries and the agents and who is that's acting on your behalf is helpful. Coordinating with your qualified attorney, your tax, financial, charitable professionals, also important. And more important now than it was a couple of years ago, gather your electronic details, because much of our lives are dealt with online. So having passwords and usernames and those sort of things available are also helpful pieces. And last but not least, take some time to communicate your wishes with your family so that they aren't surprised and they can be helpful to those who are working with we're working really in a stressful time to carry out the wishes that are important for you. And resist the urge to procrastinate, because mortality is still 100% assured. So it is important to be aware of that and make sure of that. Here's my contact information. You're certainly encouraged to follow up with questions as time goes on. And I would just say that if you're outside of the central Kansas area and want to have some connections with an Everence advisor, I certainly can help get you connected in the rest of the US. Um, and so here are the little things that nobody really wants to read, but they're important. So you get a few seconds to look at those. Um, and with that, I'm going to pause, and George, we'll see if there are any questions that might be out there that we can respond to.
Well, yes, if you have questions, I ask that you drop those in the chat and I can help get those out to everybody. Dennis, wow, lots of information. You covered that very well, giving us lots of things to think about, anywhere from a base foundation to some of the more advanced features that, yeah, all great considerations. So very much appreciate that. Let's see. Waiting for any questions. The other thing I would ask, let me check this. Yeah. Those of you not identified on the screen, I respect your privacy if you don't wish to be identified, at least to the whole group. I would love to have your name and contact information so I can do a quick follow-up in the next couple days to see if you have any questions about this or any feedback regarding the presentation. Our aim is to provide information to you so you can help make your own decisions. So I would ask, if you're willing to, if you could at least drop your name and contact information in the chat box, or just to me, that would be helpful, or contact me here in the next couple of days at your leisure, actually. So.
And I'd throw in too that next week's presentation with Randy and Cindy will also be fabulous. They're very good at what they do, and they have knowledge and experience and the legal background to do things that I don't. So I'm a certified financial planner. I'm not an attorney. So I've read a lot of wills. I've read a lot of trusts. Part of my role with Everence is to be a trust officer with the Everence Trust Company. So I've lived a lot of these kinds of situations. And let me just throw in that anytime you can do planning that clarifies what you want your wishes to be, it will be better than not doing anything. There are a few horror stories out there that we could cover if we had more time tonight of planning that wasn't done that really could have been done and would have helped a lot.
Yeah, good reminder, Dennis. Adrian Pancratz will be on next week. And that's by design, with Dennis being the certified financial planner to give you that perspective and that background, and Cindy and Randy coming on next week to give you more the legal perspective. So they work. I don't know whether you said this out loud, Dennis, but I know you were telling me earlier, you and Cindy have been touching base with each other, talking back and forth.
Yep.
This
Yep.
is a good cooperative agreement here. So
Yep. Absolutely.
I will tell you, as we're closing out here, we have revamped our website here at Belfa College, and if you would like any more information on the website, please go to Belfa College, look up giving, and then search the HROH piece. It's right there on that giving page. There's a Heritage Roll of Honor online form if you care to start that paper. Otherwise, you're welcome to give me a call or anyone here in the development office, and we're here to help you. We're definitely here to help you. So Dennis left his contact information. You can follow up with any phone calls, contacts there as you wish. without any questions I see dropped in the chat, I'm gonna go ahead and bring closure to this meeting. So thank you, everyone. Again, I did record this, so we'll see where we can post this on our HROH website. If you care to see this again, either one of you or anyone else you want to refer to this recording, it's there for your benefit. Dennis, anything else?
I'm good. Thanks
Thank you.
to all who tuned in, and thanks George and Pam for the opportunity. And let's do better than we've done in the past.
Very good. Very good.
All right. Thanks, everybody.
All right. Good night, everyone. I'm going to end it. Appreciate your attendance.